Good afternoon and welcome to another episode of Lunch and Learn. And today we will be discussing how to deal with employers that refuse to deduct in terms of a garnishee order, or like we know it as an emolument attachment order. What is the process and how do we deal with that? We will also be addressing some issues regarding the POPI Act, that is the Protection of Personal Information Act, and how does that relate to maintenance matters when the maintenance officer actually needs that information from the employers and they do not give that. Good afternoon. My name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years, specializing mostly in maintenance matters pertaining to the rights of children, as well as domestic violence, as well as divorces. And I'll be happy to host this webinar for you today in conjunction with one of my article clerks, Erin O'Neill. But without further ado, just to give you a brief rundown of what to expect from today's webinar. Erin will take you through the process and explain how does emolument attachment order work? How does the whole process of this emolument attachment orders or garnishees work? The service thereon of the order on the employer and what is the effect thereof. She'll also be touching on the time frames of deductions. So when could you expect a payment in terms of a garnishee order after the order has been served upon the employer? We'll also be addressing the non-compliance of these orders and what would happen next, where to complain, where to notify, who to notify, and what procedure needs to be followed, as well as the duty and the responsibilities of the maintenance officers relating to the non-compliance of these employers that actually just refuse to deduct those money. Erin will also take you some of the court documents that she would explain, and then lastly address the issues of POPI. Before we get right through to that, just the structure of the Lunch and Learn overviews. If you have registered, and thank you for all those who have registered on our website, www.lunchandlearn.org.za, you would have received a link bringing you to this website, or you could watch on any of our social media platforms, on Facebook, on LinkedIn, as well as our website and a couple of other streaming facilities or platforms that we use. Together with that, you would also have received a link bringing you obviously to this website where you would have access to some pre-reading material, if there's any pre-reading material pertaining specifically to this webinar, as well as the resource and templates folder, where we would put in the slides so that you could download, as well as a complete course handout for you also to download and to read at your leisure afterwards. If we refer to certain cases during the course of the webinar, it would also be made available on that specific tab. But without further ado, I'm handing over now to Erin so that she can take you through this whole process, and I'll join right at the end again and giving a summary and just highlight some of the important issues that were discussed. Over to you, Erin.
Let's get right into today's Lunch and Learn webinar dealing with employers who refuse to make the necessary deductions in terms of a garnishee order. So the first topic is explaining how the garnishee process works. There is a previous webinar which extensively dealt with garnishee orders and how you need to apply for them, what documents are needed, time frames, all of that is explained in a different webinar. You can go and consult that if you're unsure about anything. This is only going to be a brief overview with focus on the employer and non-compliance with that garnishee order. So how does the garnishee process work? Well, first and foremost, a garnishee order is a court order to enforce payment of an existing maintenance order. So it is one of the civil remedies which is available to an applicant to enforce payment of arrear maintenance. For example, there's an existing maintenance order that the respondent must pay 2,000 Rand a month in respect of the child. That respondent has now failed to make timely payments for a period of 2 months. That applicant can then approach the court and apply for a garnishee order, also known as the attachment of emoluments order, to have that arrear maintenance enforced to receive those payments. It is confirmed in section 26, 1A of the Maintenance Act, and it is a court order that is granted against the employer of the respondent to make the necessary deductions against the salary or wages of the respondent. So it allows for the deduction of money directly from the salary or wages of the respondent, and this is automatically deducted in terms of that court order. So the employer will be served with the Garnishee order together with all the notices necessary in terms of section 29 of the Maintenance Act. But we will discuss that later on in the webinar. For now, just know that a Garnishee order, or also known as an attachment of emoluments order, is granted against the employer of the respondent, not the respondent themselves, and then the necessary deductions are made directly from the respondent's salary. Section 26(1)(a) reads, whenever any person against whom any maintenance order has been made has failed to make any particular payment in accordance with that maintenance order, such order shall be enforceable in respect of any amount which that person has so failed to pay, together with any interest thereon by the attachment of emoluments. What does this mean? Basically, this means that where the respondent has been in arrears with the maintenance payments, that amount can be claimed back in terms of the Garnishee, together with any interest on that principal amount. So as we've said, it is a court order against the employer of the respondent and not the respondent themselves. The existing maintenance order is the order against the respondent, and then the Garnishee order is the order against the employer. The money is paid directly to the applicant until that maintenance order is terminated. And the court order is issued as part of the maintenance order. You can only have a Garnishee order where there is in fact an existing maintenance order. So let me give you an example. You and the father of your child have come to an agreement that you will make a certain amount of payments each month. But you did not approach the maintenance court. You and the father discussed this among yourselves. The court was not involved in this process. You reached an agreement with the father and you said that this is what's going to be paid. Now, the father has failed to make those payments. You cannot now go and apply for a Garnishee order because there is no existing maintenance order. Therefore, it is important that you approach the maintenance court in the district where you live or work or where the child lives, complete the J101 form, apply for the maintenance court order. Once you have that valid maintenance court order, and then the respondent fails to make payments in accordance with that order, then you can apply again. You can go to court, you can complete the J306, this is the enforcement order, and you can apply for the Garnishee order against the employer to enforce payment of the arrear amount that the respondent has outstanding. So it's important to distinguish between the fact that if you only have an agreement with the respondent but there's no court order, the Garnishee order is not a civil remedy that is available to you. But if you did approach the maintenance court, you have an existing maintenance order, you can base your Garnishee order on that. Section 28 of the Maintenance Act deals specifically with the attachment of emoluments. This section has been extensively discussed in a previous Lunch and Learn. If you are still unsure about this process, please go and consult that video. So an attachment for emoluments can only be issued by a court, and it must be based on a valid court order. So we've said this. You must have an existing maintenance order before you can apply for a Garnishee order. Also, there are some things that need to be understood. If you have an existing maintenance order that was granted today, you cannot apply for a Garnishee order merely because the respondent has not paid you by, for example, tomorrow. There's a date in that maintenance court order, the date on which the respondent must make those maintenance payments. If he has not made those payments for a period of at least 10 days from the date on which payment should have been made, then you can apply for Garnishee order. You cannot apply for Garnishee order any time before that. You need to allow those 10 days to pass. That period must first pass. Then he is considered to be in arrears, and then you can go and apply for the Garnishee order, which is based on your existing maintenance order. So this all makes sense now. You need the existing maintenance order because there's a date given in there that payments must be made on. Now the respondent has not made those payments on that date. Period of 10 days has passed. You can now apply to enforce your existing maintenance order to claim back the arrear amount. Moreover, if the respondent becomes unemployed, is no longer employed by the employer, there is an obligation in terms of section 29(2) on that employer to inform the maintenance officer within 7 days from the date of such unemployment that the respondent no longer works there. And this, as we said, this is done within 7 days. So the section reads, whenever any person to whom the notice relates leaves the service of the employer, that employer shall, within 7 days after the date on which he or she so leaves the service, give notice thereof in the prescribed manner to the maintenance officer of the court where the order in question was made. So as we've said, if the respondent no longer works for the employer, there's an obligation on that employer to inform the maintenance officer within 7 days from the date of unemployment that the respondent no longer works there. So the sheriff serves this Garnishee order on the employer. As we've said, he does not serve it on the respondent, it's served on the employer. It then orders the employer to make the necessary deductions from the salary or the wages of the respondent. The employer has an obligation in terms of that court order to make these necessary deductions on a specific date and in a specific manner. Section 29(1) reads as follows. So Section 29 of the Maintenance Act deals with the notices that are given to the employer in terms of this Garnishee process. In order to give effect to an order for the attachment of emoluments referred to in Section 28(1), the maintenance officer shall, within 7 days after the day on which such order was made by the maintenance court, or whenever it is afterwards required in the prescribed manner, cause a notice, together with a copy of such order, to be served on the employer, directing that employer to make payments specified in the notice at the times and in the manner so specified. Let's unpack that. So what this means is that the sheriff will serve this Garnishee order on the employer, together with a notice. This notice will contain information pertaining to the amount that must be deducted from the respondent's salary, together on the date on which it should be deducted and the manner. For example, the notice could state that 200 Rand must be deducted on the 24th of each month into the following bank account. So we have the amount that must be deducted, we have the date on which it must be deducted, and then we have the manner in which it should be deducted, so into the bank account. The next topic, usual time periods for deductions. So a Garnishee order takes effect once it's served on the Garnishee. So this is the employer. Once the sheriff has served the Garnishee order together with the notice on the employer, it will in theory take effect. However, in practice, it does not take effect immediately, and it takes up to 3 months before that Garnishee order takes effect and the money is paid into the applicant's bank account. So in theory, it immediately takes effect once served on the employer, but it might take up to 3 months before it is actually paid to the applicant. Now we get to the important part. What happens if an employer does not comply with an emoluments attachment order? So the employer now refuses to make the necessary deductions in accordance with the court order. So what happens now? An employer cannot refuse to deduct the money from the respondent's salary or wage. This court order is legally enforceable. There is a legal obligation on the employer to make the necessary deductions on the date and in the manner so specified. Those deductions must commence immediately once the employer has been served with the garnishee order and with that notice in terms of section 29(1). The court order directs the employer to deduct a specified amount from the salary or the wages of the respondent. There is no discretion. The employer cannot choose not to pay and cannot decide that this month they want to pay, next month they don't want to pay. There is no discretion in this regard. They are legally obligated in terms of this court order to make the necessary deductions. We will discuss now the remedies where there's failure to make payment and the legal consequences that will ensue upon an employer who refuses to make the necessary payments. So if the employer refuses to make the necessary deductions, the applicant is allowed to take legal recourse or legal action against that employer. What would this mean? The applicant can apply for an order compelling the employer to act in accordance with the garnishee order. Or the applicant can apply in terms of section 38 because it is a criminal offense to not comply with the court order. Section 38A reads as follows. Any person who without sufficient cause refuses or fails to make any payment in accordance with a notice under section 29(1) shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 2 years. So that means that an employer who refuses to make the necessary deductions in accordance with the notice in terms of section 29 and in terms of the garnishee order is liable to fine or imprisonment not exceeding 2 years because it has now become a criminal offence. Non-compliance with the garnishee order amounts to a criminal offence. As we've said, Section 29 of the Maintenance Act deals specifically with the notices that are sent to the employer together with the garnishee order that is served by the sheriff. And then non-compliance with the notice and the garnishee order would lead to a Section 38 offence, which is a criminal offence. We will now go through Section 29 again. As we've already said, Section 29(1) just deals with the fact that it's a notice that's served on the employer stating that they must make necessary payments. It will state the amount, the date on which it should be made, and the manner in which it should be made. Section 29(2) states that if the respondent becomes unemployed, there is an obligation on the employer to inform the maintenance officer within 7 days from the date of such unemployment that the respondent no longer works there. Section 29(3) reads, any employer on whom a notice has been served for the purposes of satisfying a maintenance order shall give priority to the payments specified in that notice over any order of court requiring payments to be made from the emoluments due to the person against whom that maintenance order was made. This provision makes it clear that those deductions must be given priority. They must be paid immediately to the applicant. Section 29(4) reads, if an employer on whom a notice has been served for purposes of satisfying a maintenance order, has failed to make any particular payment in accordance with that notice, that maintenance order may be enforced against that employer in respect of any amount which that employer has so failed to pay. This is an important provision. It deals with the non-compliance. It states that if the employer has failed to make the necessary deductions, the employer will be held personally liable for the amount that is due. So the maintenance order can then be enforced against the employer themselves. This means that the employer will be legally liable to pay the money to the applicant that is owed by the respondent, just because of the fact that they have now not complied with the garnishee order The remedy against them would be that they are personally liable for those payments. As we've said, this means that if the employer fails to deduct the necessary amounts in accordance with the Garnishee order, that employer shall be held liable for the amount owed. He or she now becomes personally liable in respect of the maintenance amount that the respondent had to pay, the employer now needs to pay. The maintenance order is legally enforceable, no longer against the respondent, but against the employer themselves, just because they have failed to make the necessary deductions from the salary or wages of the respondent. Just to recap a bit, so we have our section 38. It is a criminal offense not to comply with a court order. The applicant can also apply to compel the employer to act in accordance with the court order, or the employer can become personally liable for the amount that is owed. The next logical question becomes, can a warrant of execution be granted against the employer of the respondent? Very interesting. The answer is yes, absolutely. If the respondent fails to comply with the Garnishee order, he or she fails to make the necessary deductions, the applicant can apply for a warrant of execution against the assets of the employer. Form L is used in this respect. So Form L in terms of section 29.4 will be used. Form L is issued by court officials only, and this is in accordance with the warrant of execution. It is possible that the assets of the respondent themselves can be attached, as well as company assets. So, for example, if it is a company that specializes in moving furniture, they have a motor vehicle that they use to move the furniture, that vehicle can be attached to satisfy the arrear amount of maintenance owed to the applicant. The sheriff can now attach that asset to satisfy the debt that is owed to the applicant, just because the employer failed to make the necessary deductions. Now, he or she is personally liable, and their assets can be attached to satisfy the amount that is owed. What are the duties and responsibilities of maintenance officers relating to non-compliant employers? Here we will deal with Regulation 3 in terms of the regulations to the Maintenance Act. Regulation 3.1 states, a maintenance officer may, in investigating a complaint and with due consideration to expeding the investigation of that complaint, direct that complainant and the person against whom a maintenance order may be or was made to appear on a specific time and date before him or her, and produce to him or her on the date of appearance any information relating to the complaint and documentary proof of the information if applicable. Regulation 3.3 provides any person who fails to comply with the direction contemplated in sub-regulation 1 shall be guilty of an offence and liable on conviction to imprisonment for a period not exceeding 6 months. The next question is, which documents need to be completed and explaining the process of garnishee? So the applicant, who is also referred to as the creditor in terms of the garnishee order, is able to apply for the attachment of emoluments in the following circumstances. Firstly, at any time by consent. So this is a consent order. The respondent and the applicant will complete the J214 application form. Secondly, during a Section 6 inquiry, which is our informal inquiry held at the maintenance court in the maintenance officer's office. Informal negotiations. Thirdly, during court proceedings in terms of Section 62 of the Maintenance Act. Fourthly, if the respondent is in arrears for more than 10 days, the applicant can approach the court, complete the J306 application form for the enforcement of the arrear maintenance. And lastly, by application to court in terms of Section 28. So in those circumstances, the applicant can apply for the attachment of emoluments order. Section 26(2)(a) reads as follows. If any maintenance order or any order made under Section 16(1)(a), II, 20 or 21(4) has remained unsatisfied for a period of 10 days from the day on which the relevant amount became payable or any such order was made, as the case may be, the person in whose favor any such order was made may apply to the maintenance court where that person is resident for an order for the attachment of emoluments referred to in Section 28(1). As we've said, the applicant will complete the J306 application form, also known as the Form K, to apply for the attachment of emoluments order. This is the situation where the respondent has not complied, has not made timeliest payments in accordance with the maintenance court order for a period of at least 10 days from the date on which that court order, those payments had to be made in accordance with the court order. It is the application for the enforcement or other order in terms of Section 26 of the Maintenance Act. So the civil remedies that are available to an applicant where the respondent is in arrears with their maintenance payments. The application for a Garnishee order must include the prescribed application form, the J306, and the following documents. An affidavit stating who the person is that owes the maintenance amount, confirmation of the order that was made in favor of the applicant. So this is the existing maintenance order. You can just submit a copy thereof, and the full outstanding amount of debt and how much will be deducted every month. So how much is owed in total and how much you would like to receive per month for a period of time until that full amount is satisfied. This is what the cover page of the application form looks like. It is the application for enforcement of maintenance or other orders in terms of Section 26 of the Maintenance Act, which we know deals with the civil remedies that an applicant can apply for where a respondent is in arrears with their maintenance. Now we will deal with the issues relating to the POPIA Act, so the Protection of Personal Information Act. Sometimes employers will refuse to give certain information to the maintenance officers or maintenance investigators based on the fact that POPIA does not allow them to give this information. But we will see now that that is not entirely true and that the maintenance officers and maintenance investigators are acting in terms of law. So they're acting within the scope and powers given to them by the Maintenance Act. So when maintenance officers or maintenance investigators call employers to request information on the salary of a respondent, some employers refuse to provide personal information of employees, since they believe that providing that information is in contravention of the Protection of Personal Information Act. Maintenance officers and maintenance investigators act in terms of the Maintenance Act, which makes it lawful to require personal information from the employers. Compliance with the Protection of Personal Information Act makes it clear that where it is lawful request for information, the company can assess the information and then their information requested and substance in terms of sections 89 and 90 and make a decision whether to produce the required information. Sections 7 and 8 of the Maintenance Act empowers maintenance staff to obtain the information from an employer. Therefore, as I've said, the maintenance officers and maintenance investigators act within their scope and power given to them by the Maintenance Act. they can legally require the information from the employers, who can then give it to them, because this is allowed, because they need that information to assess the documents, and make the necessary decisions regarding the maintenance order. In the event where the HR manager or company requires a summons to appear before a magistrate, the maintenance investigator or maintenance officer can issue a summons in terms of Section 8 and summon the HR manager or the company owner to provide the information to be given under oath in terms of the Maintenance Act. So it is possible that the maintenance officer or maintenance investigator can get that information from the employers, and they cannot withhold it based on the claim that the Protection of Personal Informations Act does not allow them to give it to the maintenance officer, because they are acting within their scope and powers in terms of the Maintenance Act.
Thank you so much for that, Erin. I think the public out there does have a better understanding of exactly how it works. Now, I just want to circle back and come back to a couple of issues specifically pertaining to Garnishee orders. Now, a Garnishee order is in essence an order that is granted by court substituting the judgment debtor, with other words, the respondent, and the employer takes the place of that person that's owing the money. What is meant by that? An order is made by the court that money needs to be deducted from the salary of the employee. Now, that is an obligation by means of court order. So the employer does not actually have any reason or validation for not adhering to that. So if we look at it from the side of the employer, how would they know that it is actually a valid court order? Because we've seen so many times in practice, and there's been a couple of case law pertaining specifically to this, where there was bogus emolument attachment orders or garnishee orders issued, and then the employers are forced to deduct that monies, and they actually realized that some of these orders were bogus orders and it was not granted properly by court. So what does the employee or the employer needs to look out for to establish if that was indeed a valid garnishee order? Like I said, a valid garnishee or genuine garnishee order is an order that was made by court. It is served on the employer by means of the sheriff. So usually it is they hand it over either to the HR department or to the secretary. So that needs to be served properly on the employer. The sheriff will then show the employer the original document, the one that the court stamped, and a copy thereof is left with the employer in order to enforce that type of order, the garnishee order. So the original garnishee order must contain certain things, and some of those things are obviously a decent case number. It needs to be contained on there, a stamp from the clerk of the court that it was duly issued, and it needs also to be signed either by the clerk of the court, or if you have an attorney that is involved in this whole process, it also needs to be signed by the attorney. And it needs to contain the full names and the details of the staff member from whom the deduction should be made. That is in essence what is needed, and how the employer could actually establish if that is a valid court order. But the employee, the person that actually receives the or the subject matter of the emolument attachment order or the garnishee order, the one that needs the deductions taken from his salary, he is not without rights. There are also certain rights that is vested in that person, and that is contained in most instances in the Magistrate Court Act, Section 65, as well as the Maintenance Act, that also deals with certain specific regulations and stipulations of what must be abided by. So when a garnishee order is then granted in respect of an employee, they are definitely not without the rights. They also have the following rights, and I'll just briefly mention it so that the people out there should know, the public should be aware that it is an order that could be changed, it could be reversed by a court if sufficient cause exists in order for it to change. So the employee does have the rights. He can dispute the amount that is claimed if the amount seems to be incorrect. That we usually find where a order is made for arrear maintenance, where the debtor or the respondent is not in agreement with the total amount that is claimed. So then he would have the right in order to dispute the Garnishee order. At any stage during this whole process of deductions, if the employee is of the opinion that he does not have sufficient funds in order to sustain himself and his immediate family, the bare necessities, then he can surely approach the court in order to reduce and to vary the emolument attachment order to make it the amount that needs to be deducted from his salary a little bit less. He also has the right to be furnished with a free of charge with a statement of all the payments that he has made and the payments that was paid over to the person that is nominated in the emolument attachment order or the Garnishee order. Those are just some of the rights that the employee has with respects to Garnishee orders. So what do you do if you believe that you don't owe the money anymore, or that you've paid the amount that was stipulated in the Garnishee order? Now, the Magistrate Court Act, as well as the Maintenance Court Act, the Maintenance Court specifically, the Act, provides that an order can be set aside if there is good cause. Now, good cause could be a number of reasons. It could be that you already paid the maintenance or the arrear maintenance, so there's no need for the Garnishee order to continue, or that you've paid a portion thereof and that you cannot afford to pay the high amount because you have financial difficulties and you need that money in order to support yourself and your immediate family. Then you could surely approach the court, and that would be seen as good cause. Or that you can also prove that you are not in arrears anymore. If the order was made just only for the arrear maintenance and you paid up the arrear maintenance, then you could approach the court to terminate or to vary or even suspend the order because you've paid up the arrear maintenance. But that would necessitate you going through to court to ask for a variation of the order. It is not automatically that they just stop the order. The order will go on unless you approach the court to have that order set aside or to vary in any shape or form. So quite often we see employees leaving the employment of the employer, and there is a certain responsibility. Like I said right in the beginning, the employer is now placed instead of the employee when it comes specifically to the court order, and it could be enforced as if it was an order against the employee himself. So an employer who dismisses the employee just based on that emolument attachment order or the Garnishee order is guilty of an offense. They cannot do that. They cannot simply terminate your services just because you have a Garnishee order against your name. And we've seen that quite a number of times in practice as well. In the instance where an employee leaves the employment of the employer, then obviously it would mean that the obligations to deduct from the side of the employer would cease to exist. But up until that stage, there's a responsibility and an obligation, a very clear obligation in terms of the Act, that the employer needs to deduct that money up until a stage, the last day that the employer is still in employment of the employee, or the employer rather. And there's an onus upon the employee to obviously notify the employer that his services are terminated, and then the employer needs to notify the court in terms of there's a certain form for that, Form O, that is governed, well, we call it the J448, that is also governed by Regulation 6 of the rules of the Maintenance Act. So if the employee leaves the employment of the work that he is in, then there's a responsibility upon the employer to notify the court that the employer has left the employment, and then afterwards the Garnishee order would obviously come to an end, and that would be transferred to the new workplace of the employee. That is very often not done in practice. So we do have a time lapse where the employee simply resigns, or he gets a better job, and then there's a time period, 2 or 3 or 5 or 6 months, where the complainant do not get any form of remuneration in terms of the Garnishee order. And then they approach the court. The court would say, okay, right, then they investigate the matter, and it is established that the employee has left the employment. Now, I've had quite a number of these type of cases where we then take the employee to task, or the employer to task, to say, but you listen, there was a responsibility upon you, and it was also served in you, the Form O that I've mentioned a while ago, that you had to notify the court immediately if the employer leaves or the employee leaves your employment. And that was not done. So you are responsible for that period up until that stage that the employee left your employment. And then a warrant of execution against the property of that specific employer could be granted by court for the recovery of that amount that they have not deducted. And we've done that quite a number of times, but that is the civil procedure. Usually it is the maintenance officers are not quite keen to do this process or to follow this process, mainly because maybe they do not understand the process. But surely, yes, you can approach an attorney to assist you with regards to this as well. So when does this stop? When does the maintenance order stop, or the deduction on the Garnishee stop? Now, one needs to distinguish between 2 different kinds of orders. The one is the normal maintenance order, where you have consented to a Garnishee order, and it gets deducted from your salary and it gets paid over to the complainant. That is the one side. On the other side, there is the arrear maintenance, where the court makes a ruling and a finding to say that this is the amount of arrears that you are in, and you have to pay that off by way of monthly installments and deductions from your salary. So there needs to be a distinction between these two. It is imperative then to realize that employers needs to be compliant when enforcing the emolument attachment orders, specifically when it comes to child maintenance. So if you have a normal maintenance order that was given to court, there would not be a beginning date or an end date, because you would not know for what period of time the deductions needs to happen, because the maintenance would definitely not stop at the rate or at the reach of the age of maturity. It could well go beyond that, up until a stage that the child is self-sufficient or self-supporting. So be cognizant thereof that there might be 2 different kinds of emolument attachment orders that are in play. The one which is the enforcement of the maintenance order, and then on the other side would be the one with arrears. So you're on arrears with your maintenance, you go to court, there's proceedings there that happened in terms of Section 28 for enforcement of the arrear maintenance, and then an order is made specifically for the arrear maintenance that needs to be recovered. In such an event, there would be a specific amount on the Garnishee order saying that you owe 50,000 Rand, or whatever the case might be, and that is the total amount that needs to be deducted, and only after that amount has been paid over, then the emolument attachment order or the Garnishee order would lapse. There's a couple of interesting cases that I read up and that I think is worth noting. The one was a case that was handed down by Judge Desai. It pertained to mostly the credit agreements, and it was brought by Stellenbosch Legal Aid Clinic and 16 other people against certain organs of state and a whole grocery list of microlenders. So it was all about the microlending. But for all practical purposes, what happened there was that the debtors had to sign blanket forms, just normal consent forms, where they consented to emolument attachment orders or the Garnishee orders. And then the judge looked at the whole structure and the whole mechanism of how it was done. And the court ruled that the wording of consent to to judgment and the consent to the jurisdiction that was obtained by the clients or by the debtors as the basis of a Garnishee order was actually unconstitutional. The ruling, the words judgment debtor had consented thereto in writing in terms of section 65J2A of the Magistrate Court Act was inconsistent with the Constitution of the Republic of South Africa, because they do not have any judicial oversight over the issuing of these emolument attachment orders. Interesting in terms of the maintenance, it's dealt with the Maintenance Act itself, not with section 65J, although there's a grave comparison between the two, and the courts would definitely look at both instances. So the question that might be asked is, if you consent to an emolument attachment order when you did the section 6 inquiry, would that also fall under the ambit of this case that I just mentioned, the one Stellenbosch Legal Aid Clinic versus 16 others, because you consented there? And the answer there, to, in my opinion, would be no, because the provisions of granting a emolument attachment order in terms of section 28 of the Maintenance Act is completely different to a large degree than the provisions of section 65J2A of the Magistrate Court Act that deals specifically with debt collection. Now, we deal with maintenance here and not debt collection, so that might be a distinction between the two cases, but this is definitely a noteworthy case. Another case that also needs to be brought to your attention is African Development Bank versus TN. That was a 2018 ruling where the judge referred to two criminal cases, where the judge then specifically mentioned that when they make an order for a garnishee in terms of section 28, now that's the enforcement of the arrear maintenance, then the act should afford the employer the opportunity of commenting upon the feasibility of the proposed order. So what, in short, what that means is that the judge felt that it is necessary for the employer also to come to the party to state, have the opportunity to state why it should not be enforced. Like I mentioned, that was done in context of criminal proceedings, not quite applicable to the normal run-of-the-mill where the respondent in the office of the maintenance officer's office consent to a garnishee order. But it is also a well worth case reading, and I've put the link there as well. That is basically just a rundown of the garnishee orders and how it is enforced. We see that nowadays that the maintenance officers are more keen to issue the garnishee orders right at the beginning, and they ask the respondent's consent to do that, even when they're busy with a Section 6 inquiry, in order to deduct the money from their salary. Now, remember, if the respondent then consents thereto, they cannot appeal that order, because it's very similar to Rule 43 of the High Court, or Rule 58 of the Regional Court. That could not be appealed. If you consent to a garnishee order, it could not be appealed. But what you could do, if there is good cause shown, then you can ask for a variation thereof. And that is, we see what is happening in practice. Because it is an easier mechanism, an easier enforcement mechanism, if they have a garnishee order in place for you as the complainant to get that money at the end of the day. That was basically just a rundown on the garnishes and how it is enforced by law. Thank you so much for listening to all our registrants. I see we've got quite a number of people all over our social media. I see LinkedIn, there's quite a lot. Facebook, there's a lot. Sure, there's a lot of people listening. Thank you so much for joining. Please register for the next webinars. We also have upcoming, we have a divorce week, a divorce awareness week. We will be discussing all the issues pertaining to divorce and giving you some insights, some holistic approaches of the whole idea of divorce. So please register for that as well. As always, you're most welcome to drop us a line at info@lunchandlearn.org.za if you have any queries or any comments with regards to any of these webinars. If you need more information, please do contact our offices as well. We are there to assist and to help where we can. Thank you so much for joining us. See you next time, same place, same time, and have a very good afternoon further.